Do you know what is it that run these companies?
They have quietly invested in many software giants.
I think this is now the era of software.
We're in the dawn of a new era of software.
High-tech software.
Frankly, is waking up to the needs of software and what software can do for them.
It is softwares. Softwares are very important and it runs everything that you see around. In this video, I'll tell you that if you are a business who requires software or apps for its operation, or maybe in the future you might require so, then you need a software developer agreement. Let me tell you why.
The office registered over 400,000 claims to copyright for millions of works.
Over a barrage of copyright claims.
Samsung's tried to get iPhone sales banned in other countries with its own copyright claim.
Softwares are copyrightable. That's it. That is the issue. And it is not about one country. In many countries, softwares are copyrightable. And if you somehow breach the copyright law, you might find yourself in some deep trouble. In some countries, you could even go to jail for this. Now you must be wondering why I am telling you all this. You are smart, diligent. Why would you breach the copyright laws? In fact, you are not even developing your own software or apps. And that is the issue. I'll assume that you might not know the technicality behind each and every codes which are being fed for your creation, which you might own. Now what will happen if the certain part of these codes are copyrighted by somebody else, and this copyrighted code will be part and parcel of your software which you will own? What will happen? It could be either fine or jail, or could be both. So how fair is it for you to suffer the consequence for somebody else's act? And the answer is obvious. It's not fair. So how to make sure that you do not end up suffering for such consequence? Or is there any legal way to handle such situation? In such situation, we put indemnification clause in the contract. And do not take my word for granted. This is the norm which is being followed by any sensible law firm.
If you are entering into a contract, it is very, very important for you to have a indemnification clause in the agreement.
If you do not have an indemnification clause, then you will be in a deep trouble.
It will make sure the developer is responsible for his doing and not you.
So, by now, we are on the same page that if we are contracting, we need to have indemnification clause which indemnify us. But this is not the end of the story. So by now we have been assuming that if the software is being created by the software developer for you, the owner will be you and not the software developer, right? Many a times, if you do not have any software development agreement, or might be having a weak software development agreement, which is worse than having no software development agreement at all, and in future if your business start to do amazing, then it's a very common practice that software developer could claim ownership of your company's intellectual property right. Consequently, it creates copyright dispute. Here, the story doesn't end. Even if you propose a very solid ownership clause in your contract, it might not work. It did be impractical in so many cases to claim that if you're creating software for me, each and every code will be owned by me. Wait, why? Here, to understand this, we need to talk about music. I know where is it going, but it's very important. And trust me, we are sticking to this topic only. In order to create music, or say some music developer developing music for me, then ideally I should be owning the copyright over the music if I transfer the copyright from the music developer to myself. Now let's talk about the behind the scenes in the creation of music. What are the things that are required for the creation of music? Maybe a computer hardware, a microphone, or sound like sa re ga ma, and God knows what else. And here, you just can't claim copyright over all of these things. You can't claim copyright over sa re ga ma. There are so many things that are required for the creation of music, and these things repeatedly are being used to create unique music. And you just can't claim copyright over all these basic stuff. In same manner, software codes work. You just might not get copyright over all of it. There could be some certain part of the code which might be being used by the developer again and again on different projects, and naturally the developer won't be giving the copyrights over such codes. So here the lawyer will come up and negotiate on your behalf with the software developer, as in what are the portion of the codes which would be used again and again by the software developer in some other project. Whether with those codes which would be used repeatedly, can a similar app be made, can a similar software be made, and there will be another aspect of such negotiations. And as you might know, there is just too much work. Then out of nowhere, the developer will come and offer negotiations.
Let's do the joint ownership.
This way, you could also own all the codes which I really do not want to give copyright of. And there is no need of negotiation. Let's just get done with it. And this sounds so amazing. And here, you should hold up your horses because it has huge implications. For example, in United States, your co-owner could just commercialize your software IP without your consent. Here you go. Software developer agreements are very complicated, and if it is not properly executed, there could be consequences. Someday or other, you might be finding yourself knocking the doors of the court.